Mr. Durst is here with Mr. Chesnoff and Mr. DeGuerin and Mr. Bailey and Mr. Milius, Mr. Henderson and Mr. Miata. Join Mr. Lewin, who is at the lectern. Our witness has returned. Dr. Loftus, you remain under oath, and you may continue your cross-examination, Mr. Lewin.
Thank you. Dr. Loftus, on January 3rd, 2012, did the following exchange between you and I take place on the phone with Mr. Wygotsky, the defense attorney, also on? Question. And ma'am, can you put it up, Ethan? Might help as well. Question. This is me speaking. And ma'am, I told you, okay, ma'am, I won't record this. Let me back up. I apologize.
Objection. I have never seen this before.
This is a transcript.
Presented to counsel before you display the
Okay.
jury.
This is from the testimony.
Okay.
Report.
Silently.
Jackson case.
I have a minute, I guess.
Yeah, you can look at it.
Thank you.
Yeah, I know. So he can look at that one part.
So is it just this?
Yeah.
I won't read.
Goes to the next page.
Continues to right here.
Okay, I won't read your notes.
Okay.
This is your outline?
That's my outline.
Good Lord.
It's not as long as your
Never
expert's
mind.
resume.
All right,
Come on,
all right.
come on, guys, let me read. Here we go.
Your Honor, I think in advance would it be possible to move the easel so that we can actually see the TV?
Well, you won't be referring to the diagram?
No.
Then
She will. Well, not on cross. Can I grab it, Your Honor?
you may.
Sure you don't want to leave to do
Yeah, I
that?
can ask for Mr. Chesnoff and
No.
to help as well.
Runner, maybe we have a moment. Now that-
You need a
Yes.
sidebar?
Now that
Okay,
I never saw this before.
okay.
Not
That's why you get to look at it before it's projected.
Here, you can have it back.
Agreeable back there.
Okay.
All right.
Dr. Loftus, the following exchange took place in court when you were testifying on March 26, 2012. Question, and ma'am, I told you, okay, ma'am, I won't record this, but do you recall telling me saying during the conversation, how on earth can you oppose me taping our conversation when your whole field of work deals with what people said and what they remember? Wouldn't the tape recording be the best evidence of what you said to me? Do you recall me saying that to you? You responded something like that, yes. I then asked you, do you recall what you said in response? You responded, I don't remember exactly what I said, no. I said, how about this? This is the first time ever in 40 years that I've been asked to be taped by a prosecutor. Do you recall saying that? You responded, something like that, yes. Question, do you recall also saying, I haven't had time to reflect what the ramifications are? Does that sound like something you said? Answer, I may have said that, yes. Then I said, ma'am. You said, response, that was how I felt. Question, ma'am, what ramifications could there be with me recording what you say and what I said other than taking the whole issue of memory off the table? Answer, I don't know whether you're going to take things out of context or twist them and not present the full story. Question, so let me understand this. So if I'm taping you, ma'am, there's a tape recording of what we say. Your concern is that I could take things out of context or not present the whole story in a recorded interview? Is that what you're telling this jury? And you answered yes. Does that refresh your recollection, ma'am?
No, it doesn't, but I see the word, you read the words accurately, but I don't have a recollection of this conversation.
Well, let's start with a couple of things. First of all, you previously had testified that you had no memory of ever speaking to a prosecutor in your 40 years.
No, of being interviewed by the prosecutor, yes.
Correct. I'm sorry,
Yes.
being interviewed by a prosecutor prior
I-
to your testifying.
I didn't recall that. So
In it-
that's
in-
how memory is.
Right. In addition, in this explanation, you said, this is the first time ever in 40 years that I've been asked to be taped by a prosecutor. Would you agree that implies in your answer that you've had conversations with prosecutors, but that they haven't asked to tape them. Would you agree that would be the reasonable inference from that response?
No.
What would the reasonable inference be, ma'am? Doctor?
I had no recollection of ever being asked to be taped by a prosecutor.
Wouldn't the answer be, I've never spoken to a prosecutor in advance about a case I'm testifying in? Wouldn't that be the answer?
I don't think it's the case that I've never spoken to a prosecutor.
So, listen, you've testified that you have never spoken to a prosecutor in advance of you testifying in a case.
I had no recollection of ever being interviewed by a prosecutor.
Well, when I say spoken, I don't mean hello in the hallway. Just so we understand where we're coming from. You now agree, you would agree, doctor, that in fact, yes, you have had interviews with at least one prosecutor prior to your testifying in a case. Would you agree to that?
If this is a correct transcript, yes, it looks as if we had a conversation.
You're not going to dispute the accuracy of the transcript, are you?
No.
All right, so you would then agree that this transcript demonstrates that you had a conversation with myself in 2012 in advance of your testimony, correct?
It appears so, yes.
And you would also agree that because it's very clear in the transcript that the defense attorney was on the call, that you would not be able to argue, well, I didn't want to talk to the prosecutor because I was afraid that he would misrepresent what I said. Would you agree that would not be an appropriate answer? Grounds?
That's my question.
It's argumentative, Your Honor. He's-
Overruled.
I don't recall this conversation, so
So instead of you recalling it, you can read it. So what I want you to do is I want you to assume for a moment that this transcript is accurate. I want you to further assume that the transcript demonstrates that there was a conversation that you had with myself and the defense attorney on the Jackson case. Do you follow me so far?
yes.
I want you to further assume, doctor, that in advance of that conversation, when I picked up the phone, that I asked you, can I record this? Are you following me so far?
Yes.
I want you to further assume that your response was, no, you may not record it, or that you prefer that it not be recorded.
Well, you'll have to show me my response.
Well, I'll read it to you, okay? I said do you recall, let's back up. Ma'am, I told you, okay, ma'am, I won't record this, but do you recall telling me, saying during this conversation, you know, ma'am, you're an expert on memory. How on earth can you oppose me taping our conversation when your whole field of work deals with what people said and what they remember? Wouldn't the tape recording be the best evidence of what you said to me? Do you recall me saying that to you?
No.
Your answer at the time, something like that, yes. That's if you could look up, you want me to bring the transcript up to you?
She's got it right in front of her.
Okay.
Well, I bet you're leaving out the next two lines where I clearly say I don't. Somebody move it up, please. I don't remember exactly what I said, no.
So let's talk. Doctor, you testify frequently about the difference between gist and peripheral details, correct?
Yes.
The gist of this would be that you told me that you did not want the call recorded. The peripheral details would be specifically how and what you said. Are you telling me that the gist of that conversation, of that testimony, is not you saying you don't want it recorded? Is that your testimony?
The gist is that I appear to have been uncomfortable with the idea of you tape recording me.
And here's what I want to ask you, doctor. You've spent your career talking about how memory is not reliable, how police officers need to tape interviews. And yet, even with the defense attorney on the line, you tell a prosecutor, I don't want you to tape me? How on earth could you justify that?
I was feeling uncomfortable.
So I assume I was feeling uncomfortable means I can't justify it. Take a moment, feel more comfortable, and explain how it is that you can turn down a recording being made of an interview you're having when a defense attorney is on the line.
I apparently was uncomfortable with the idea.
As you sit here today, doctor, would you concede that the idea of a memory expert who testifies that it is important that everything be recorded, herself saying, I don't want to be recorded, is hard to rationalize with your field of expertise.
Objection, argument.
Sustain.
As you sit here today, do you think that your answer, you're saying right now that you're uncomfortable, do you think that that is an answer that is consistent with how somebody who is an expert on memory and who has repeatedly stated that police officers need to record every interview they do? Are those two versions consistent?
There are assumptions in your question that I don't agree with, so I can't answer the question.
There are, okay. What assumption is in my question that you don't
I
agree
don't know
with?
that where I've said police officers need to record every single interview. I don't know where I've said that, and that was an assumption in your question.
Oh, so, doctor, is it your testimony that you have not lectured on the idea that the problem when you're assessing whether memories have been implanted in witnesses who have spoken to police officers is that if the interview is not recorded, you can't assess the propriety of the interview? Have you testified to concepts similar to that?
Yes.
So can you explain to me then how on earth you can turn down a recording of an interview which would have served as the absolute indisputable evidence of what took place during the conversation? Can you explain that?
I think the explanation is in the answers that I gave. I was not comfortable with it. I didn't know what the ramifications were. It was a surprise request, and I would have needed more time to think about it.
So you would need more time, doctor, to think about whether or not you will agree to have a conversation with a prosecutor with the defense attorney on the line recorded. What would you need more time to think about?
I don't know. I didn't get more time to think about it, so.
Well, take a moment and think about it now, please, and give me your answer as to how you believe that this is in any way consistent with your entire area of expertise and research.
I can't think of an answer to that.
And the
I don't
reason-
know what it was at the time, 8 years ago or whenever, why I was uncomfortable with the idea of this conversation and
Well-
taping it.
Well, you started off with Mr. Chesnoff explaining that the reason, this was yesterday, so I assume you remember it, that the reason that you don't speak to prosecutors is because you want it done in front of a judge. That was your answer. And the implication of that was that you were concerned that what you said might be twisted or unfairly represented, et cetera. Is that correct?
Well, you'll have to read back the testimony from yesterday. I don't remember that saying it exactly that way. In my practice, I did not recall having conversations, being interviewed by prosecutors in 40 years of criminal cases.
So, doctor, my question now is not whether you recall it. My question now is you have now accepted, you've now agreed that the transcript demonstrates, and your affirmation to it back in 2012, near the time that it happened when your memory was fresher, that you had said you did not want the interview tape. So my question to you is, how on earth can you yourself, a memory expert who disputes how statements can influence memories, how improper questioning can influence memories, how on earth can you say, I'm not going to allow this to be taped?
I stand by the answer I've already given to that question.
Which is what? I don't know?
Your Honor. Yes.
The answer is I don't know. I can't explain. What's the answer?
I was uncomfortable with this suggestion. It came out of the blue, and I had no time to think about it, so that was my preference.
So, doctor, my question to you would be, how much time would you need to think about an offer by a prosecutor to say, I want to tape this conversation, which you agree, taping would have preserved exactly what was said? What would make you uncomfortable about having your words taped, other than the fact that you wouldn't be able to change them later?
If I had to think about it in the future, I might agree to it if the judge ordered it or requested it.
So what you're saying then is unless you're ordered to have by a judge to have a conversation taped, You don't want a conversation taped. Is that what you're saying?
No, I just need more time to think about it. Maybe it wouldn't be so bad and it would be okay to do. That would be fine. I just had no time to think about it on the spot, obviously, 8 years ago.
I want you to imagine a scenario, Doctor, where you had a detective on the stand, and he was told the information in the case was that he had done an interview with a witness, and that witness had stated things that you were addressing through hypotheticals regarding their memory. I want you to further assume that that detective did not tape the interview. Would you not be the first person up there saying and telling the defense attorney, hey, listen, cover with him the idea that by not taping it, we don't know what was actually said. We don't know the tone. We don't know the intonation. We don't know whether they were feeding this witness information. Wouldn't those all be things you would point out?
Yes, I think it'd be helpful to have tape recording, and that's why I've advanced the idea.
So you advanced the idea for police officers, just not for yourself.
I don't know how many times I need to say this and bore the jury, but this
I
was
don't
a
think they're bored,
surprise
but keep
request,
going.
and I needed more time to think about it.
All right, let's go on. So as you sit here today, do you have any better answer? Right now, you have some time to think about it as to why you would refuse to have an interview taped. You agree that would be the best evidence of what was said.
Yes, I think it would be.
And if it would be the best evidence of what was said, can you give any rational explanation today as to why you would say, nope, don't tape?
Your Honor, that's been asked now by my count 5 times.
It-
Overall,
I don't have any further thought to add to what I've already said.
So I just want to clarify, you agree that if there was a recording, you would have understood that you would be held accountable for what you would have said, correct?
Well, could be repeated back to me, yes.
You would also agree that you're not saying, it wasn't the defense attorney telling you not to record the call, correct?
I don't recall.
Well, let me ask you something, Doctor. When you testified, if you were doing it at the instruction of the defense attorney, wouldn't you have said during the exchange, listen, I wanted you to tape it, but Mr. Wygotsky said no? You agree you would have mentioned that.
Probably, right.
So the fact that you didn't, you would agree, it would appear that it was your decision not to have it taped, not the attorney's.
It would appear, yes.
Let me ask you, you agree that also has nothing to do with your shyness about having a statement of yours taped, or, you know, an issue with you not wanting to have your voice recorded, correct?
I don't have an issue about that, no.
In fact, you do extensive media, including interviews, profiles, etc. Is that right?
Well, I am interviewed quite a lot by the media for one reason or another.
And if you go on YouTube, you'll find hundreds of videos and lectures you've given, TED Talks, 60 Minutes interviews. I think you've appeared on Oprah. Is that correct?
I did have a brief appearance on Oprah, yes.
So I'm just trying to establish the reason that you're saying no to the taping is not because you have some philosophical issue with, I just don't want to have myself taped. You do media and interviews that are taped and interviews with reporters that are printed all the time, correct?
Yes.
Isn't it true that the reason that you didn't want to do that interview, you didn't want it taped, was because you were concerned that you were going to say something that I could use to impeach your testimony when you came in here as a paid expert, when you came into that case to testify for the defense? Isn't that why you didn't want to do it? You understand that under California law, you are under no obligation to speak with a prosecutor like myself. Is that correct?
That's my understanding, yes.
And you further understand that you characterize yourself as an unbiased scientist. Is that correct?
Yes.
You've said that it's your role in the past, you want to educate the jury and you want to explain to people the things that are behind your research and opinions. Is that correct?
Yes.
So, Doctor, can you explain then, why did you refuse to speak with me in this case?
I already testified about that earlier. It was not my practice. I had no memory of ever being interviewed by a prosecutor. And given examples of the kind of interviewing, I just thought it'd be better to have this conversation in front of a judge.
So, is it true, doctor, that in essence, are you telling me that you were afraid that somehow I would conduct an interview with you and that you would be unprepared or would be at some significant disadvantage in answering my questions regarding the work you've done in this case? Is that what you're saying?
No.
Well, so if you can explain, please, tell me why is it that as an unbiased witness, you weren't willing to sit down with the prosecution in this case, with myself, with a defense attorney present, recorded, et cetera, and explain in advance what you were going to be doing in this case? Why?
Do you really want me to? Because you're a bully, and I didn't want to subject myself to that unpleasant experience.
Okay, so, by the way, if I was a bully, wouldn't it be recorded and you'd be able to come into court and then you could testify how mean and cruel I was to you and how I misrepresented, et cetera? Wouldn't you have been able to do that?
Oh, that's kind of a thought. I hadn't thought about that.
Okay.
But
So it had nothing to do with your bias then?
it had to do with what I've already testified about.
And are you aware, doctor, that my efforts to contact you go back more than a year?
I don't recall getting a phone call from you, even though you apparently claimed you called my office, but I don't recall that.
Isn't it true, doctor, that Mr. Chesnoff had to call you repeatedly and email you and had to tell you, hey, listen, the prosecutor's been leaving you messages, voicemail and email, for over a year and you haven't responded? Are you telling me you didn't have that conversation with Mr. Chesnoff?
I do believe I told him I did not receive any emails or voicemails from you until much later.
Have you ever responded to anything I've sent you, even to say no, that I don't want to be interviewed?
I contacted the attorneys and they said they would respond.
Isn't that correct, doctor? That did not happen until a couple of weeks ago.
Well, I'm not quite sure when or how often they responded, but it was left to the attorneys, and they felt that communications coming from them would be more appropriate.
Isn't it true, doctor, that Mr. Chesnoff made a phone call where he left a voicemail message telling you that I was standing next to him and saying, this is proof that I am calling you, Dr. Loftus, and telling you to please respond to the prosecution? Are you disputing that happened?
I'm sorry, I don't recall that.
Your memory's not very good, is it?
Well, I have a normal memory, but, and it's imperfect, like most people.
Your memory is kind of worse on the things that don't make you look very good, correct?
Objection, Your Honor. Argumentative.
Sustained.
All right. You've said you are a completely unbiased witness, just here to tell the truth. I want to ask you, you've written a number of books, is that right?
Yes?
Does one of your books have the following quote about you seeing a prosecutor in court? Quote, the prosecutor was tall and thin with a long straight nose, sideburns that looked like they were trimmed with a ruler, and fingernails neatly clipped and shiny as if they'd been buffed. Good morning, doctor, he said, smile definitely forced. I've never met a prosecutor who was happy to see me in the courtroom. Did you write that?
You'll have to show me
Oh,
the
okay.
passage.
Any idea what book this is from that you wrote?
Display it to counsel first.
This is called,
Okay.
It's called witness for the defense, Your Honor.
you wrote a book literally that you titled Witness for the Defense. Is that correct?
That's the title of one of my books, yes.
So you seem to not remember, etc. Let me approach you, and I want you to look at page 147.
You can use the projector.
Put on the envelope. Okay.
See, you forgot that.
One second here. You know what, Doctor? I've got, my page site is wrong, but you've been asked about this previously. You would agree that, Doctor, there is a portion in that book where that exact quote that I just said, where you say, "I'd never met a prosecutor who's happy to see me in the courtroom." Is that right?
I just don't recall that, or the context in which I might have said it. It was 1991 when that book was published, so
I take it back.
decades ago.
Right. Mr. Milius has found it. I want you to look at the bottom of page 147. Read the last line.
Definitely not you.
It's not coming up on this
Wow,
screen.
that was, I think there's a thing about glass houses, Mr. Chesnoff, that I would watch out for.
I'll take my chances.
Anytime you want to step on a scale, I'm ready to go. Let me know when you're done, Doctor.
What is it you want me to be reading? Where?
Well, again, I'm going to read it out loud for you. I'll start. The prosecutor was tall and thin, with a long, straight nose. That's the bottom of page 147, top of 148. Sideburns that looked like they were trimmed with a ruler, and fingernails neatly clipped and shiny as if they'd been buffed. "Good morning, Doctor," he said, his smile definitely forced. "I'd never met a prosecutor who was happy to see me in the courtroom." Ma'am, Doctor, excuse me. That's what you wrote, correct?
Well, that was in that book from 1991, a description of something that happened in one of the trials that I was involved in.
Okay, so in a book, let me answer my question, Ken. You wrote, correct?
Well, I and my co-author wrote, yes.
Your co-author, your
Mr.
secretary,
Lewin,
correct?
Return to the lectern.
I'm sorry?
Instead of shouting at the...
Your co-author, your secretary, correct?
Instead of shouting in my ear.
That's why we have the lectern.
Your secretary. Are you going to blame the passage in that book on your co-author who was your secretary?
I think your question is misleading. The co-author of the book was my secretary for a number of years. She went on to be a successful writer, and she co-authored that book with me.
So, Doctor, was the example that was given on 147 about you'd never seen a prosecutor who was happy to see you, did that pertain to your co-author, or did that pertain to you?
No, the book is about me and my experiences in court cases.
So, as an unbiased, simply scientist wanting to get to the truth, why on earth would a prosecutor, quote, I've never met a prosecutor who was happy to see me in the courtroom? What did you mean by that?
What I may have meant, it was 1991, so this is just a speculation, is that typically I am called by the defense and in a criminal case, and so probably prosecutors are not that happy when I come into the courtroom to testify on behalf of the defense, which I think is true of you.
Oh, I'm thrilled you're here. Trust me. I would have driven you myself. I'll drive you home if you want.
All right, enough.
So,
Move to strike.
Yes, stricken.
Doctor, do you think that in any way, shape, or form, that comment is in any way neutral or unbiased?
It was just an expression of something that's probably true.
Sounds like, you tell me if I'm wrong on this, sounds like a very egotistical comment of somebody who is basically saying, I'm a hired gun for the defense, and when prosecutors see me, they're not happy when they know I'm there. Is that a fair characterization of the comment?
Absolutely not.
Well, then you give me a fair characterization, please. Explain it.
Testimony on behalf of a defense or a defendant that has to do with the malleability of memory and communicates the science of memory and memory distortion, and
Motion to
perhaps
strike is
provides,
non-responsive.
I'm in the middle of my answer, perhaps provides an explanation for why somebody might be saying something that isn't true and accurate, that's not something that many prosecutors want to see.
So the motion to strike is denied.
Doctor,
Don't interrupt the witness.
Doctor, your point with that comment, you don't just say that prosecutor, you say you'd never met a prosecutor who was happy to see you. That's because you are a hired and extremely expensive gun, correct? You're a hired gun.
I don't consider myself a hired gun. I'd be saying the same thing if I were working for free.
Well, but you don't work for free, do you?
Many times in the past I have.
Oh, we'll be going through that. Okay, let's continue. Let's talk about the title. Does the title, Witness for the Defense, sound unbiased to you?
I believe that title was actually chosen by the publisher, and it was meant to be kind of a takeoff on Witness for the Prosecution, or kind of an Agatha Christie title.
And as a scientist who makes their living being unbiased, did you say to the publisher, hey, publisher, wow, I testify in court how I'm just a scientist, I'm not on one side or the other, and if you title my book, Witness for the Defense, it makes me seem like I'm biased in favor of the defense. Did you raise that issue?
No.
And in fact, you agree that even if, quote, the publisher picks the title, by 1991, when you wrote this book, you were a very respected, esteemed expert who certainly had the credentials and the power to say to the publisher, no, I'm not naming it that.
I didn't dispute that at the time.
Who was Witness for the Defense dedicated to?
You'll have to show that to me. I don't recall right now.
I'll read it to you and you tell me if this is accurate. We dedicate this book to the women and men who have been wrongfully accused, convicted, imprisoned, or have otherwise suffered because of faulty eyewitness identification, faulty eyewitness testimony. Does that sound right?
That sounds right, yes.
Anything about victims in your acknowledgement or dedication in this book?
No, it was about the wrongly accused and wrongly convicted.
You agree there are a number of photos in the book as well, is that correct?
In the hardback version, yes.
And you have photos included of different people that you've represented, infamous killers like Ted Bundy, is that right?
Objection, Your Honor, to the word.
Yes, sustained.
Individuals where you have testified for them at trial, being paid for by their lawyers, correct?
There are some photographs in there of either individuals who are mentioned in the chapters, or sometimes I'm in a photograph with them or with their lawyer.
Do you have even one photo of a victim in that book?
I don't think so, no.
Let's talk about your past client list. Who's Ted Bundy?
Ted Bundy was tried for an aggravated kidnapping in the mid-1970s. Before anybody knew he was the Ted Bundy, and I was an expert witness in that trial in the 1970s in Utah.
So it's your position, listen to my question very carefully, that at the time of that trial, doctor, there was no discussion of Ted Bundy being a serial killer with victims in Washington at the time.
At the time, Ted Bundy was a first-year law student at the University of Utah Law School. He was accused of this attempted kidnapping, and there was some, I think there maybe was some mention around that time, or wonder whether he had been involved in some crimes in Washington state, but
Doctor,
none of that was known except for
Doctor,
sure.
some crimes in Washington state, or at the time he was in custody in Utah awaiting trial, he was suspected of being one of the most notorious serial killers in the history of Washington state.
Well, I don't know all of that. I mean, I don't know how much of, I just don't know.
Doctor, are you going to tell me, to your testimony, you're telling this jury, that when you took that case, that you had no idea that Ted Bundy was suspected and being investigated for being a prolific serial killer?
Object, Your Honor, may we talk for a moment, please?
Sidebar?
Yes, please.
Okay. Just be a moment, ladies and gentlemen.
Thank you, Your Honor.
You're welcome, Mr. Chestnut.
Can I
Mr.
continue, Your
Lewin,
Honor?
you may continue.
So, Doctor, I just want to be clear. Although the cases had not been litigated yet, you were well aware when you took the case involving Ted Bundy that he was a suspect in numerous murder cases that he had committed in the state of Washington over a period of a number of years. Is that correct?
It's 45 years ago. I believe that I remember there was a rumor about the possibility, but we knew nothing about what
Okay.
ultimately would transpire with Mr. Bundy later on after he was convicted in that case.
Hillside Stranglers, Kenneth Bianchi and Angela.
Yes?
Continuing 352 objection.
Oh, okay. I will,
Ponder.
you need not speak. I'll rule on it should I hear something that's more prejudicial than probative.
Thank you, Your Honor.
Going through your client list, Hillside Stranglers, Kenneth Bianchi and Angelo Buono. You testified in their trials, correct?
I testified in one of the trials, but I don't remember which one. It was maybe quite a long time ago.
You worked on both cases, though, correct?
I may have worked on both cases. I worked on at least one of those cases, for sure.
Timothy McVeigh, you worked on his case, correct?
I did consult on McVeigh. I did not testify, but I actually had a chance to meet him.
Right. O.J. Simpson,
I consulted on that case. I did not testify.
the Menendez brothers,
I consulted on that case, but did not testify.
Michael Jackson,
I consulted on two of his cases, but did not testify.
Phil Spector,
I consulted on that case and did testify.
Your Honor, my objection's continuing.
Right, overruled.
Thank you.
Martha Stewart.
I consulted on her case, but did not testify.
Who's Jerry Sandusky?
He's accused of molesting students in conjunction with the Penn State scandal.
Wait, accused or convicted of dozens of counts of molestation?
He was convicted, yes.
You worked on his case, correct?
Well, I primarily was working on behalf of the Penn State administrators who were accused of knowing and maybe not reporting things that they may or may not have known. And then after their case was resolved, I did consult on the Sandusky case.
So,
It might have been after the trial. I can't remember right now.
Doctor, the last question I asked you, which is pretty simple, did you work on Jerry Sandusky's case? And your
Yes.
answer was, instead of saying yes, what you did was you got out a story that you wanted to get out about who else you had represented.
Objection, Your Honor.
in
That
that
is
case.
Go back
argumentative.
to, wait, hold on. What's the objection?
It's argumentative. He just got out a story.
No, overruled. Start your question over from the
Doctor.
lectern.
I asked you a very simple question of if you worked on Jerry Sandusky's case. Instead of answering yes or no, you brought up the fact that originally, even though the answer to that is yes, you had worked to represent Penn State. Did you not understand my question, or did you simply want to include that extraneous information?
Well, there were other individuals that I was primarily consulting with in that case.
I asked you a very simple question. Did you represent Jerry Sandusky? The answer would be yes, correct?
I consulted on the case, yes.
Bill Cosby,
I consulted on that case too.
Harvey Weinstein.
I actually testified in the Weinstein trial.
Did anybody force you, doctor, to take those cases?
Nobody forced me, no.
In taking these cases, did you make any determination or not as to whether the charges against these men were untrue?
That is not my role. That's the jury's role to take in all the information and make that decision.
So again, doctor, I asked you a yes or no question, And instead of simply saying no, you again answered with extraneous information that you apparently wanted the jury to understand. So again, if I ask you a yes or no question, will you answer my question, yes or no? Mr. Chesnoff can follow up on redirect. Do you understand?
Your Honor, would you please control the manner of questioning? Thank you.
Your Honor, I'm going to ask the court to have the witness answer. The court's already said it to her twice. There was a yes or no question. She did not answer my question. She answered a question she wanted to answer. Can you advise her, instruct her to please answer what she asked?
I think it's fair to question and answer, to follow up on why it wasn't exactly the answer did more than simply answer the question. You may inquire about that. The witness has testified for her reason for doing that, which is to give context and explanation, and you can explore that as well. You may not make an argument with your question. You may continue.
Your Honor, my request to the court is that if I ask her a yes or a no question, and I don't think there's any issue that she couldn't answer the question without the extraneous information, that she answer the question that I asked, and that counsel can.
Not as speaking as a
It's not a speaking
It is.
objection. It's
Yeah.
it's a request of the
Yeah,
court.
you shouldn't be arguing these things in front of the jury. I've warned you about that before. Don't do it. It is
Yeah.
appropriate. Don't do it. Stop.
I'm asking the court.
Stop. Quiet. I am going to speak with the witness. So, the attorney has asked some questions that call for a yes or no answer. And so you should answer only the question and answer it appropriately. And sometimes the question cannot be answered yes or no. In that instance, you may explain your answer. However, the lawyer will follow up with additional questions about your explanation.
Thank you, Your Honor. Doctor, you would agree that in fact, when you take a client's case, their actual guilt is not a factor in whether you take the case. Is that correct?
When I get involved in the case, I don't know if they're guilty or not.
Let me ask my question again. When you take a case, do you ever go, wow, there's 30 different women accusing so-and-so of X crime, or there's 10 different women this serial killer is charged with killing? The evidence looks real bad, so you know what? I'm going to apply my skills elsewhere. You don't do that, correct?
I wouldn't even begin to know until I started reviewing materials in the case.
So you're saying, as an example, you had to review materials in the Cosby case to understand that he was accused of sexual assaults on numerous different women. You didn't know that until you reviewed the file. Is that your testimony?
Just because somebody is accused by many people doesn't mean they're guilty.
So this is my question again, doctor. What I'm asking you is, do you agree that you do not, when you take a case, you do not go and assess and say, hey, you know what? Wow, there's so many different witnesses saying similar things, or there's so much evidence that I'm aware of that I'm not going to take the case. That's not what you do, correct?
That's not typically what I do.
Have you ever done that?
I have refused to work on a couple of cases, yes.
Well, you've actually only ever, as far as I know, you've only publicly commented that you ever refused to work on one case, and that was Ivan the Terrible, who was the prison guard at Treblinka in World War II, and you refused to work on his case, correct?
He was accused of being the operator of the gas chambers at Treblinka.
Known as Ivan the Terrible, correct?
Yes, he was accused of that.
That's where you drew the line of where you were going to represent. Is that correct?
No.
You didn't, so why not him?
No, I also refused to take a case where the victim was a friend of mine.
Well, wait, what?
Pardon?
How would you even ethically be able to take a case where you knew the parties, where someone was a friend of yours? Is that you turning down a case, or is that you complying with the ethics of your profession that say you cannot take such a case?
I don't know about any ethical rule, but when the defense attorney contacted me to work on a case and the victim was somebody I personally knew and was a friend of mine, I said no.
Doctor, if you had accepted that case, you don't think that would have been an ethical violation?
I hadn't even thought that far.
You hadn't thought that far. Let me ask you right now. I want you to think about it right now. I want you to assume that tomorrow somebody comes to you and they want you to testify in a case where a friend of yours is a victim. Wouldn't you agree, doctor, that you would have to say, I cannot ethically do that because I am personally have knowledge and relationships with somebody who's a part of the case? Isn't that what you would have to say?
No, I don't know that.
So you might take such a case.
It could happen that I would take a case where it could happen in some circumstances where I might work on a case where I happen to know somebody who was making an accusation.
Well, you didn't say you happen to know. You called the person a friend of yours.
Well, she was a friend, yes.
So for the right amount of cash, would you take a case that involved a family member who was accused of crime? I just want to know where the line is.
I don't understand your question.
Okay, let me be real clear. You've said that you don't think there's an ethical obligation necessarily to turn down a case where the victim is a friend of yours. Let's say the victim is a family member. Would you ethically have to turn that case down?
Well, I don't know about the ethics. I don't know what the ethics are, but I would probably I would feel uncomfortable if it were a family member.
You're
Yes.
telling this jury 50 years as a researcher, 50 years in the top level of academia, and you're telling this jury that you don't know if it would be an ethical conflict for you to take a case where a named victim was a family member. Is that truly your testimony?
Just show me the regulation. I don't know that. I've never seen that written anywhere.
Would you think it would need to be written anywhere, doctor? Don't you think it would be understood that you cannot testify in a case where your family member is the named victim? Would you think that would need to be a regulation or written out? Wouldn't you just understand that?
No.
Okay, let me move on. Isn't it true, doctor, that you've had many of the criticisms of the cases that you have taken have been because you've represented many wealthy and powerful people who paid you lots of money?
Some of the people whose cases I've consulted on are wealthy and some are poor. Some of them have paid a fair amount of money and some haven't. There have been all kinds of cases.
So please listen to my question. I'm going to try again. That's not what I asked you. My question is, you've been criticized, correct, by people inside and outside of your field for some of the clients you have willingly taken on who are accused of horrible crimes, but who are very wealthy and very powerful. That has been a criticism you have received. Is that correct?
There have been people who have not been happy about that, yes.
So would the answer to my question be just a straight yes?
Yes.
If you can, doctor, it would save us time if you can just answer my question. So I'll try another one. The individuals that I just named, Ted Bundy, Hillside Strangler, Timothy McVeigh, O.J. Simpson, the Menendez brothers, Michael Jackson, Phil Spector, Martha Stewart, Jerry Sandusky, Bill Cosby, Harvey Weinstein. Do you actually believe that the individuals that I just named were victims of either false memories or bad identifications, your areas of study?
It's not my position to judge whether they're guilty or not, but there were memory issues in those cases.
Right, and you were happy to take the check, correct?
I actually didn't get paid in all those cases.
So let me ask you, the clients that I just named, was it your quest for fame, your desire for money, or both?
Neither.
Neither. Have you ever told anybody any comments about how excited you were to be working on the Harvey Weinstein case?
I don't think I ever told somebody I was excited to be working on it. No, I actually tried to recommend another expert in that case and almost succeeded.
So Rachel Aviv, the woman who did the extensive profile on you in New York Magazine in 2000, what's that?
New Yorker. ER.
I don't know why I have New York Magazine. Thank you, Mr. Chesnut.
You keep saying that.
Yeah, doctor.
Doctor, the extensive profile that was in The New Yorker by Rachel Aviv. You discussed your work on the Weinstein case, is that correct?
I did talk with her about that to some extent, yes.
Do you remember saying the following? This is in her article, quote, "I have to admit that it is fascinating to me, you know, in the trenches with the trial of the century." Do you recall saying that to her?
I don't remember exactly that, but I do believe I said to her that because I am a true crime buff, it is interesting for me to be able to look inside some of these cases and see what's happening.
Right. By the way, what were you paid on Harvey Weinstein's case? What was your rate?
Well, I made an arrangement for the 4 days in New York. That's 4 days I was going to be away from my office for a fee of $14,000, $10,000 of which was paid.
Did that cover all of your work in the case?
That cut, basically, yes.
So your total billing for the Harvey Weinstein case was, you said, a total of how much money?
I made an agreement to do that for $14,000, $10,000 of it was paid.
And when you made the agreement at the time, your rates were $600 per hour, correct?
That's correct.
And when you went to work on that case, that is originally what you negotiated and expected to be paid. Is that correct?
I do remember making the arrangement because his staff said that he had cash flow difficulties. We settled on this figure of $14,000, and I agreed to do it. And the full amount was not paid.
You were thrilled and excited to be in the midst of what you thought was a trial of the century, weren't you?
I was trying to give that case away to another expert, recommended another expert. They liked the other expert. They hired the other expert. And I thought I had succeeded in solving the difficulty I was having by then by allowing this somewhat unpopular person to have an expert, but it turns out there was more pressure put on me to actually do the testimony, and so I did.
Doctor, when you use the words, you're not disputing, just want to be clear, you're not disputing that you told the author, quote, "I have to admit that it is fascinating to be, in the trenches with the trial of the century."
You'll have to show me that because I thought I was talking generally about being in these high-profile cases and how interesting it can be. I don't remember that it was about that one.
So I want you to assume for a moment, and I can show you at the break, I don't want to use the time now, that you made that comment, that quote was made, et cetera.
But I don't know that that was about the Weinstein case. I don't believe it was, actually.
If the article stated that you were talking about the Weinstein case and made that comment, are you saying it wouldn't be true?
Yes, I'd have to see, you'll have to show me, because I believe I was speaking generally in being involved in a case, and Michael Jackson and Martha Stewart and other interesting people. It is fascinating.
It's interesting, and also for you, for a lot of these witnesses, or a lot of these defendants, extremely well-paying. Is that correct?
Sometimes I am well paid and other times not.
Would you consider $600 an hour to be just well-paid or extremely well-paid?
Actually, I now charge $700 an hour, but I don't raise my rate in the middle of a case, so I would not be raising the rate in this case. But it's now $700 an hour because experts in my field, some of them are charging $1,500 an hour, and they are younger and less experienced than I am.
So it being 12 o'clock, I think we'll just have to remain on the edge of our seats on this one. Mr. Lewin, you may pick up where you left off.
Any openings I can apply for over the lunch hour?
Ladies and gentlemen, do not converse among yourselves or with anyone else on any subject connected with this case. Do not form or express any opinion on the case. 1:30 p.m. will return. Before we also break.
No, Your Honor.
Thank you, and have a nice break, everyone.